Okay. Thanks everybody for joining. I know it is getting kind of close to the middle of the new month for the new year, so I hope everybody's had a pretty good start to that. But just to introduce myself, my name is Skylar Corbin. I'm the current speaker chair for Tulane Law's Sports Law Society, and today we've got a really exciting panel for you. We've got three panelists who will be talking to us about intellectual property as it pertains to sports law and entertainment law. So first, I'd like to start by introducing Ms. Jordan Franklin. Ms. Jordan Franklin is an associate attorney in the intellectual property group at Kearney McWilliams and Davis, PLLC. She focuses primarily on trademark, copyright, and contractual matters in industries such as entertainment and media, fashion and beauty, business, and the like. Prior to joining KMD, Jordan was the owner and managing attorney of the Franklin Law Group, where she represented small businesses and entrepreneurs in various IP matters. She is currently a member of Minorities and Intellectual Property Law Association, Texas Accountants and Lawyers for the Arts, the American Bar Association, and she serves as a member of the Trademark Committee under the Federal Bar Association IP section. In her spare time, Jordan loves traveling, watching college football, and learning and working on her golf game. Next, we have Mr. Darren Adam Heitner, Esquire. He is the founder and lead attorney of Heitner Legal, PLLC, which is a law firm with many practice areas, including sports law, contract law, and trademark law. So Mr. Heitner has also represented numerous athletes and sports agents as legal counsel. He also served as adjunct professor at Indiana University Bloomington from 2011 to 2014, where he created and taught a course titled Sports Agency Management. And now he currently serves as an adjunct professor at the University of Florida Levin College of Law, where he teaches a sports law class. Additionally, Mr. Wagner served as a lead contributor to Sports Money section of Forbes from 2012 to 2018 and was a sports business contributor at Inc.com from 2015 to 2018. In 2005, Mr. Heitner created the Sports Agent blog, which has since that date served as a lead publication in the space surrounding NCAA and sports agency news, interviews, information, and opinion. Mr. Heitner currently writes for Above the Law. From 2011 to 2018, Mr. Heitner served as a co-founder of Collegiate Sports Advisors, which consulted with universities and assisted their athletic compliance departments in setting up professional sports counseling panels, agent days, and athlete agent education materials. He has published over 16 full-length academic law review articles on a wide range of sports law topics, including NCAA regulation and athlete agents. He has also authored a sports law treatise called How to Play the Game, What Every Sports Attorney Needs to Know. You should all put that on your book list and make sure you get a copy. And he's also appeared on ESPN, CNBC, CBS News, and other television stations to speak on sports business and sports law topics. And as of late, in 2019, Mr. Heitner was asked by Florida Representative Chip LaMarca to assist with the crafting and promotion of legislation that seeks to provide Florida college athletes the right to profit off of their names, images, and likenesses. And the bill has passed both in the Florida House and the Senate. And also, just recently in 2019, Mr. Heitner was named to the University of Florida's 40 Under 40. And in 2020, he was honored with the University of Florida's Levin College of Law's Outstanding Young Alumnus Award. And he has also been named a Rising Star by Super Lawyers from 2015 to 2021. And last but not least, we have Mr. Luke Bedlam, who is a partner at Porter Wright in their corporate department, leading the sports law practice group. He brings a well-rounded approach to the challenges athletes face at any phase of their career. Working with an athlete's team of advisors, he provides the essential, objective, thorough, and balanced counsel necessary to leverage the opportunity at hand. Luke regularly advises a range of clients, from student athletes transitioning into professional sports, professional athletes navigating life on a team, to retiring athletes creating the game plan for their life after sports on matters including marketing, contract analysis, immigration issues, investment opportunity, due diligence, asset protection, real estate development, brand and mark protection, as well as trust and estates. And prior to joining Porter Wright, Luke served as a legal manager in the mergers and acquisitions area. and Director of Business Development at the Scott's Miracle Group Company. He leads the advisory firm Anomaly Sports Group. So please give a warm welcome to our panelists. Just as some housekeeping before we get started, there are quite a few people here today, so I'd just like to remind everybody, if you do have questions, you can direct message me in the chat feature, and I'll ask those in the last 15 to 20 minutes or so of the panel. But just to get started, we'll start in the order that we introduced everybody. Ms. Franklin, could you please answer the question, what drew you to sports law and the practice of intellectual property in particular?
So good afternoon, everyone. I would say I'm more on the entertainment side than I am the sports side. Okay, can you hear me okay?
We got you now.
Okay, perfect. So yes, I'm actually more on the entertainment side than I am the sports side, as far as, you know, the IP matters that I handle. And what drew me more to the entertainment side is my background in particular. Granted, I haven't played in a long time, but I'm actually a classically trained pianist. And then I spent about 8 or so years in symphony. My private lesson teacher actually in high school is the principal clarinetist for the Houston Symphony here. So I have a musical background basically, but I knew I didn't want to be a musician professionally. So basically when I law school, my thing was, okay, well, I love art and I love the creative process and that creative aspect of, you know, music in particular. So my thing was, what is a way for me to continue to contribute to the arts world, but not necessarily be an artist anymore myself? So that's kind of what drew me to this area, because copyrights in particular directly impact musicians and creatives. So that's kind of what started my journey that way.
Thank you for that. How about you, Mr. Heidner?
Well, first of all, thanks for doing this. And I appreciate everyone coming on here today. My path is a little bit different. I actually went to law school without the intention of ever practicing law. So my goal beginning back in 2005, when I had the opportunity to intern at a sports agency called CSC, which is in Atlanta, Georgia, was actually to be a sports agent and not to be a practicing lawyer. In fact, I had created a sports agency mere months before even starting law school back in 2007. I knew that I wanted to work in sports, so when I started law school, again, thinking that I wouldn't actually practicing in the future, I decided to take classes that actually interested me. I recall taking classes like copyright, trade secrets, cyber law, and a class on analysis and drafting intellectual property, which led me to believe at the time that if I was ever going to actually practice law, which obviously I ultimately did, I would like to build a book of business in that space. And so again, I knew that I always wanted to do something in sports. I thought that it would be sports agency. I didn't think that I would actually be practicing law. And then when I ultimately went to law school, took the dive in, knew I was going to be there for 3 years, decided to make the most of it, take classes that interested me, and that was in the realm of intellectual property. And so since graduating, I've tried to marry the two. It's the best of my ability.
Thank you. Last but not least, Mr. Fedlam.
Hey, thank you so much. And thanks for having me. Thanks for having this conversation. I think it's a fantastic opportunity that I always love being a part of, so that I can learn from both panelists as well as from the audience. So thank you for doing this. What drew me to sports law it's kind of interesting. My thought when I was an undergrad was I wanted to go on to law school and be a corporate lawyer and call it a day. But I was so tired of undergrad that I was like, I need a break before I go into law school. So I took an opportunity in finance, and I worked in an investment firm in Philadelphia. My plan was to do that for a year, maybe 2, and then go on and go to law school and just do corporate law, corporate transactions. But I ended up being there for about 5 years at the investment firm, really enjoyed what I was doing, learning a lot. And then from there got recruited to go to a sports management startup working with athletes on the financial side. So having no plan to get involved in kind of the sports or athlete kind of world, I found myself in as a financial advisor, wealth manager for athletes. And in doing that for a few years, what I realized was I really wanted to protect these athletes so much more than get them a better return than the market or lose less money than the market's losing, at the time. We brought lawyers in for kind of a lot of different areas to help these athletes from, real estate transactions, due diligence on deals, intellectual property protections, et cetera. And a lot of times these attorneys, while experts in their particular substantive area, really didn't understand the unique challenges that the athletes were facing on a daily basis. And so I found myself kind of being the translator between the two. And it got to a point, I was in the military. I was in the National Guard. I had a year of active duty time. And during that year, that's when I was just like, if I'm ever going to go to law school, I better go ahead and do it before I get too old. Decided to go into law school, and the rest is kind of history. What I love about, what I do is just as much as being a legal counselor, it's about educating. And it really is about educating athletes on the challenges that they face and on these different areas. And I know we'll talk more about it as we talk more specifically about IP in some of these areas. And so for me, it's just been a great fit of being able to work with athletes to help educate and ultimately help protect them.
Thank you. And, kind of what the common theme here is, the reason I asked that question, we do have quite a few students on the call, and sports and entertainment is obviously a very attractive space. So it's always really important to remember what your why is for getting involved. And each of the panelists have really done a good job of explaining that. But my next question to each of you is, what qualities do you think make a good intellectual property attorney?
So I'm gonna say hunger. I think that's the biggest thing. So I'm not that far removed from you guys. I've been licensed now for 2 years. So I'm still learning and stuff every day, but I will say IP in particular. So a majority of my caseload is actually dealing with trademarks. There's actually some of my registrations behind my head, but majority of my workload deals with a lot of trademark work. IP is one of the areas, in my opinion, from what I've seen and based on conversations I've had with my colleagues that practice other areas, we're the fastest moving. So because of that, it's something that you consistently have to stay abreast on. I read all the time. I write articles and stuff for my firm all the time. Just making sure that I stay up to date with what's happening, what's going on, especially because also there's crossover with what I do in entertainment. There's a lot going on in the news as far as like celebrities and like trademark issues, brands and trademark issues. So just kind of staying up to date on all of that stuff. Like you read a lot. People don't even know that there's an update to trademark law. Congress passed the Trademark Modernization Act in 2020, which happened at the end of December. So those are, now things that are in effect to a law that's been in existence for, longer than I've been alive, technically. Now there's updates to keep it quote unquote modern. So just staying up to date with everything is the biggest thing. So that hunger goes back to making sure that this is something that you're actually passionate about and you want to keep learning because it's ever changing. So you kind of have to have like that hunger and that drive to consistently like stay on top of like what's going on and what's happening. I think that's personally what I think.
I actually think that is a fantastic answer. I agree wholeheartedly. I think IP, along with really every area of the law, is always evolving. And I certainly have considered myself to be a student every day since graduating law school back in 2010. And I'm always trying to learn more and keep on top of changes in the space. I certainly think staying abreast of the changes makes a good intellectual property lawyer. I firmly believe, whether it's IP or any other area of the law, you have to have knowledge of the subject matter and enough experience to quickly spot issues and respond immediately and when necessary. I'd also say I think what separates a good IP attorney from a great one is probably the ability to effectively communicate what are oftentimes very complicated topics to clients so that they're well informed and so that they also feel as though they're part of the process. I find that clients really appreciate that when you're not just taking on an issue and then talking to them months later down the line, but keeping them abreast of what's going on throughout the process. For instance, if there's a trademark filing, you may not be assigned an examining attorney to your application until 3 months later. And at that point in time, things kick up, and it's always important to keep your clients informed in the process, because if they don't hear from you 6, 7, 8 months down the line, you may have a problem. And again, I think it's not only having that knowledge and real understanding of various intellectual property issues, but also strong communication skills, and then also the ability to communicate without sounding condescending. Because again, it's a complex area, so you want to be cautious to not come off as though you know everything. Be humble, but also show your expertise to your clients, because that's what they're hiring you for.
Yeah, I think that's everything that's been said is spot on. I guess the only thing that I could add to it is maybe to add a little bit to what Darren was saying, which is I think, the same things that will make you a great intellectual property lawyers are the great thing, the same things that'll make you a great lawyer, period, right? Which is being able to be a counselor, an educator, a communicator with your clients, a student of, whatever area interests you. So I think those are all the things that will help you to be successful in IP in particular, if you will. So I don't think I would classify myself as an IP lawyer directly. I deal with intellectual property work with my clients on a regular basis. I know enough to be dangerous, and then when necessary, bring in the experts in our IP practice for that. And so, but what I try to do is always stay engaged, right? So I'm always understanding as they're explaining, new areas, new changes and things like that, so that I can be, a student of all of these different areas where my clients need assistance. In doing that, though, it's also important to understand. For me, it's important just as much to understand what are the new trends, new changes, new areas of IP law. It's also important for me to continually be a student of the industry, right? What's changing as it relates to how my clients are engaging in new platforms on social media, in the creation of new ideas and new ways to express whatever their brand is, right? I mean, it's like I constantly see kind of my role is having to understand them, so that when they say something off the cuff like, hey, I just I'm getting to be a part of this new platform that hasn't been made public yet, but it's going to involve X, Y, and Z, I can say, okay, great. We need to have some conversations around these protections that we want to make sure are in place. So it's just as much you being a student of the industry and the clientele that you want to work with, as much as being a student of the substantive area of laws that you find yourself in as well.
Thank you for those responses. And that was kind of the thing that I heard amongst all three answers, was that being able to stay on top of the trends and remain a student of the game, or of the practice rather, is particularly important. So that kind of follows up into my next question, which is, what trends are you noticing in intellectual property, and how has it evolved since you began?
I guess for me, I've been practicing a shorter amount of time than my two colleagues. I will say for me, the biggest trend that I've seen is like the impact of social media and your brand protection, especially. And that kind of, I won't say makes it difficult. I'll say it makes policing, especially your trademarks, a lot more interesting. So normally what I say is, at the beginning, I'm your trademark lawyer. Once we get your registration, my role then converts from trademark attorney to your brand protection attorney, because now there's different things that are in place to make sure that your brand is protected and it maintains, those protections. So one of the biggest things that I've seen is, of course, social media and like how big it's become. Staying on top of potentially like infringing activity. I will say platforms like Instagram do a phenomenal job with like their reporting system. I actually had a page taken down this morning that was infringing on one of my clients' rights. So, I mean, we're taking them down quick, but it also involves more involvement with my client. I know Darren touched on it earlier as far as like having them a part of the process. I tell my clients, like, after we get a registration, we have a follow-up call. Okay, you're registered. Congratulations. This is what this means now. So one of the things that I advise them to do, I have social media. I'm not as active on it. And I, in no means at all, have the bandwidth to like police all the marks that I trademark like at one time. So I usually have my clients do homework, search your hashtags. Hashtags are just search mechanisms. So if you have a certain brand name, search that hashtag and see what comes up, because that could lead you to potentially a page or, another brand that is doing some infringing activity, which is how, the client that I took the page down for, that's exactly what happened with her. So I think that's one of the biggest things that I see right now, is just kind of staying on top of that as far as like social media and like how it's expanding and how it's used and stuff like that.
Jordan, we may need to retain you if you've got that secret sauce to Instagram. I'm actually looking at a text message from a client today who, unfortunately, the reporting tool was down. We were trying to report an imposter on Instagram, but maybe earlier in the day it was working for you. Yeah, look, I mean, the trend is really that intellectual property is always changing. As we just talked about, keeping abreast of the changes are really important. I can give an example in the realm of copyright law, where not too long ago, there was a split among the jurisdictions on the federal level as to when a copyright claim could be brought in federal court. And then somewhat recently, the Supreme Court made a decision that you actually have to obtain and possess a copyright registration prior to initiating a case. In many jurisdictions, that was not necessarily true. So that's a trend that if you're not keeping abreast of what's going on in the world of intellectual property, you may not know. And then you file a complaint and you get kicked back a motion to dismiss, and it's going to be dismissed with prejudice. Another trend that I'm closely following, as Jordan mentioned, is everything that's going on online. And what I notice is, and this is particularly true in the realm of athletes and celebrities and influencers, is that many of them are not aware of what is or what is not fair use, or even that fair use is a concept in itself. You have a lot of infringement that is occurring online, and fair use may be a defense, but it has to be analyzed on a case-by-case basis. And again, what we're starting to see are a lot of cases. LeBron James has been sued. Deshaun Watson has been sued. Other athletes have been sued for posting content belonging to other individuals without consent. If you're a photographer, you take a photo, you own the copyright to that photograph, and somebody else cannot use that without consent, again, unless there's fair use. And you may think to yourself, well, if I'm just posting a picture on Instagram, that's fair use. Except if you're LeBron James and you have sponsorships in place and you're getting compensated for posting various content on your social media, then it could be argued that in total, your account is really a commercial use. And this is just one component of that total commercial use. So it's a very interesting area of the law. I think we're going to see more and more cases arise based on online activity. And the hope is that not only we as lawyers, you as law students, but even non-lawyers are educating themselves as to what is proper, what is not, and what to analyze on a case-by-case basis.
Yeah, I don't know that there's too much more that I could add here from what Jordan and Darren mentioned. I think I think the only thing that I'll say in addition to that is maybe to take it from the perspective of content, right? If it, you know, so I started working with athletes in like 2005, 2006, and that's crazy because that was before like the first iPhone came out, right? So, and you think about how like it doesn't seem like it was that long ago for me anyway. But man, like a lot has happened since then, and you know, at that time, athletes generally were still kind of at the power of traditional media, right? The Sports Illustrateds, the ESPNs, like the traditional media, print and television that we know of. And just what's changed over the 13 years, plus is the content. And now athletes have the ability to own content and to produce their own content and to share their message. So whether they're doing it through social media, as Jordan and Darren, talked about, or whether they're creating platforms for athletes to then be able to deliver other athletes content themselves. Think Players Tribune, think, other platforms, or, Players Tribune as it originally kind of came out. But, just thinking about that aspect of being able to facilitate the delivery of content, that's something that's a major difference. And I think we're going to continue to see that as athletes continue to realize kind of the power and the leverage that they have in this space. We'll continue to see new technologies and new ways for athletes to be able to get their content to fans and to the world. And with that, I mean, it continues to just raise intellectual property issues left and right as it relates to ownership, licensing, et cetera.
Thank you. And the next thing that I kind of want to ask, keeping in mind that intellectual property is so central to the brands of athletes and entertainers, what kind of cases or instances can you think of as of late where the failure to secure those rights have kind of resulted in things going awry for a client? Just kind of highlight the importance of securing those rights.
I feel like I don't even know like how to sum this up because I see it happen all the time. People don't realize the importance of a trademark until it's too late. A lot of the time, you have a client. I had a client in particular. They're an advertising company. They do, if you ever go into a Walmart and see like the cardboard pop-ups with like the gift cards with the batteries and stuff like that, it's one of my clients. They do all of those for Walmart, and they've been in business longer than I've been alive, almost. I was born in 1990. I think they started their business in like 92. So they've been around for a really, really long time. And they waited until last year to go ahead and start the procedure of getting a trademark. We ran into some hurdles. That's where the lawyering comes in. Thank God. Our client actually got a likelihood of confusion rejection based on an application that was filed by Kendall Jenner, or the Kendall Jenner Kardashian clan. I was able to like successfully argue why there was like no similarity between the two, and we ended up getting the registration. But had that been a different story, he may have been, almost 30 years in business without any type of trademark protection because he just waited that long. So it's kind of one of those situations where a lot of people don't realize the importance of them until it's too late. So I usually try to advise early while you're in the development stages, filing LLCs, corporations, nonprofits, whatever that looks like, and you're coming up with names early. You should also be looking to potentially trademark, like at least at the beginning, or what the trademark availability could be, because that may be a name you need to change from the beginning. So I say, like, I hope that answered your question, but it happens so often that sometimes we have to be the bearer of bad news. And I'll ask, usually before I segue into the bad news, is, well, how married are you to this name? Because then my follow-up question is, you may have to abandon it, and here's why.
Yeah, I mean, all over the place. As I mentioned, there's the Deshaun Watson case where he's being sued for use of a photographer's content without consent. There's LeBron James is being sued for use of content without consent. We're going to keep seeing those types of cases pop up. There was a huge copyright infringement case between Nike and Kawhi Leonard last year, where Kawhi was with Nike for years and then left. And there was an issue. Actually, Kawhi brought the case because he was seeking a declaratory judgment that he could continue to use that claw mark that is so recognizable and affiliated with him. And there are many issues with how he brought the case. He actually brought it in the wrong jurisdiction at first, so it was a mess from the start. But then later on, Nike prevailed, and Nike prevailed largely because in the contract itself, Kawhi assigned all rights to Nike. And it was very clear that Kawhi's initial version was very different than the final version that Nike used, which was the ultimate version that Kawhi wanted to continue to use for other pursuits with different brands. So that was a very interesting case. Just before we started this Zoom today, I saw a tweet that was really interesting by a colleague who brought up the fact that Urban Meyer doesn't even own the trademark registration to Urban Meyer. It's owned by Ohio State. And so I dug into it right before this Zoom, and I found out that in May 2012, he assigned all rights to Urban Meyer to Ohio State. But what's really interesting about that, and I don't know if it's Urban Meyer being lazy. I went to the University of Florida, so I have mixed emotions when it comes to Urban Meyer. But I don't know if it's him being lazy or his counsel dropped the ball on this or whatever. But I looked at the actual assignment document, and it says that once his agreement with Ohio State is terminated, which happened quite some time ago, all he has to do is request that Ohio State assigns back the rights to Urban Meyer, and in fact, assign the trademark registrations to Urban Meyer. So now people are talking about it on Twitter, the fact that Ohio State owns the trademark registration to Urban Meyer, and obviously that could have simply been prevented if he made a simple request to Ohio State to transfer back. I doubt it's going to end up in any litigation, but point being made, these are types of things you want to keep track of and make sure that you actually own your intellectual property, and that if you're using content that either you have consent by way of a license or it's been assigned to you. And if you want to actually own it, more important than anything, always remember this, especially, well, particularly when it comes to copyright. The person either has to be an employee of yours doing work within the scope of employment, which is usually not the case. So let's say you hire someone to create a logo, make sure you have a work for hire agreement so that all right, title, and interest is being transferred from the creator to you or to your client. Very important.
Yeah, that's super important. You know, I agree with you. I think those cases all are probably the more important ones to kind of hit on now. One thing I will say I'm in Columbus, Ohio, don't represent Urban Meyer. In his defense, it could be, or in defense of his counsel, it could be that that he's technically still employed by Ohio State. He's like in this random position of associate athletic director, assistant athletic director. So it could be the fact that he still has that employment that once, as I think many folks around the world believe that he will become be coming back down to Florida to coach a professional team down there, then we may see that assignment actually happen. So I really won't add too much to what's already been said. I see, side note, it's always a sign of good panelists when the last person to respond to the question always says, like, there's not too much more I could add, because they literally have like hit on everything that's great. So fantastic discussion. I think what I'll add to the question, I think, is, you know, I have a lot of athletes, and Jordan and Darren both hit on it in terms of the individual brand protection for their own brand. But what's interesting is athletes are getting more and more aware of that, right? Like, I need to make sure I do something to protect my brand, even if they don't know the technical side of IP and trademark and all that. Like, I've had athletes that have said, like, hey, I need a patent so that I can protect my name. And it's like, okay, let's take a step back. We'll talk about how this all works out. But so they know they need the protection, but what they forget, I think, a lot of times is when they start businesses, right? And just to like what Jordan was talking about earlier, you know, a lot of times we have athletes who are starting, you know, businesses around whatever, pick an industry, pick an area, clothing, transportation, whatever it might be. And they don't think about that. And to Darren's point, we've had many situations where athletes come to me and say, hey, I've got this logo that we're using. Or I say, hey, where did you get that logo? And it's like, oh, my buddy drew it for me, or whatever that might be. Hey, did you pay for it? Do you have anything in writing? Like, no, but we're cool. Like, it's all good. That right there is like the kiss of death. Don't, like, anytime a client ever tells you that, like, no, but we're good. That's my friend. That's my buddy. Let's look out for problems down the road. So it's this whole idea of helping athletes understand the totality of this kind of protection, how it's both their individual brand and the protection that's needed there, but also just as they develop, businesses, operating businesses, et cetera, to make sure that they still apply that same level of IP, of trademark and brand protection to their business.
I want to jump on top of that for 1 second, because the "we're good" comment just came up a couple of days ago with me. And so, I was talking to an athlete who sent me content that was created for him, and it was a logo. And I'm like, do you have a work for hire agreement for this logo that was created? And he's like, oh man, it was created back in 2014. We're good. I'm like, I don't care when it was created. Do we have anything in writing that assigned the right title and interest? And he actually got very aggressive with me. And, and it's a client that I've had for a long time. So at that point, you always want to CYA, cover your ass. You put it in writing, you make sure he understands, just in case later on he's going to start commercializing with it. And then, problems could happen. So make sure that you provide the proper advice, and then ultimately you're the fiduciary, the client's the principal, they choose what they want.
I actually wanted to add something too that both of them said from a musician standpoint. A lot of label deals may have, and often do have, some sort of clause to where it says something along the lines of, basically, we own all of your IP. And then you're in a situation like Megan Thee Stallion, she's from Houston, I'm in Houston, to where now there's a trademark dispute, or potentially a trademark dispute between her and her label. They already have the contract issue, which made more news, but underneath that is a trademark dispute that's probably going to happen because they own the trademark to all of her stage names. Megan Thee Stallion, Tina Snow, they own the Hot Girl Summer trademark, and just the list keeps going on and on. So what I advise musicians in those instances is, before you sign a deal with the label, go ahead and file for those rights yourself, to where at least you already own it. And if there is some type of assignment that can be done, it could be like an Urban Meyer situation, to where the assignment is on a temporary basis. And if there is a situation to where, you're no longer a part of that label anymore and you leave, it's not a situation to where they maintain your IP. It can be, written to where they assign it back or something like that, but not where you're like asked out, basically. And that could happen. And it often does happen when they don't read or don't take consideration to those IP clauses in a lot of label deals. So that's just from a musician standpoint.
And I just want to say, too, because this ties back, I think, to one of the first questions that you asked, right? What makes a great IP lawyer? Like what you're hearing right now, that's what makes someone great, right? To be able to say, listen, I know that everything is good right now, that you're all excited because the label wants to work with you, or you're all excited because you got this logo and you've had it and all that kind of stuff. But as counselors, as advisors, as lawyers, like, we have to say, listen, and I tell my clients all the time, like, you pay me to be skeptical and to like worry for you, right? And so I know that I'm always the one that comes up with the what ifs and the bad, stories about what could happen, but it's based on reality. And these situations happen. And so you have to be able to meet with a client at the very beginning of your relationship, and when they're talking to you about what they have going on, project out to them and tell them, like, well, guess what? We need to do these things, because if not, down the road, this could happen. And if you think about it, especially from an artist perspective, a musician's perspective, there's so much excitement. I don't typically work with musicians, and Jordan, has spoken to this, like, but the few times that I have, it's oftentimes like, they're so pumped at the beginning, like I can't believe people want to hear whatever, my music, hear my beats. You know, I'm so excited that this label wants me to be a part of it. And then you fast forward and it's like, okay, well now all of a sudden you're huge. And it's like, you don't, you know, you've given up so much on the very front end. And so it's being able to be that counselor that can kind of stop the hype machine a little bit, because we're getting paid not to be hype people, right? We're getting paid to ultimately protect them and their interests, you know, both now and in the future.
Yeah, one of the things that I've noticed about attorneys that I really respect is just having that ability to have foresight when it comes to problems that arise like that. So it's great to kind of hear that from all three of you. And we do have about 17 minutes left, and we've got a lot of questions in the chat. So I'll move over to those because I could ask questions all day. But our first one's from Mr. Burton. And the question, he says, is primarily for Luke. What should you do if you work at a firm that doesn't have a sports and entertainment group, but you have a large potential book of business and the firm isn't providing the proper resources to adequately serve them?
Call me. No, I'm just kidding. I mean, you can't actually call me, but no, I think there's a couple of things, right? One is you have to make a decision, right? We are kind of owners of our career, right? We are the ones who, you know, the harbingers of kind of our own destiny, right? So, you know, when you think about it, it's like, is the firm the right firm, right? Do they provide the right kind of general resources for you to best advise your clients or your potential kind of book of business? And even if they don't have a sports practice, then start talking to them about the possibility of having a sports practice. And if they're not on board with the possibility of having a sports practice, then you think about that potential book of business that you have, and you have to make this decision for yourself, but think about the book of business you have and say, okay, what are their needs, right? So does the firm all of a sudden be okay with this book of athlete clients if they fall under the fact that they're, you know, clients for in their IP space, right? And then maybe I'm doing some corporate work for them as well. And, you know, now we're doing some real estate work because they're getting into real estate deals and things along those lines. So from that perspective, I don't think you have to come to the firm and say, hey, I've got this great master plan for building out a sports practice. But a lot of firms are happy to hear that you have clients that have needs, you know, for the legal services that are provided. So that's one side of kind of keeping it where you're at. The other side is if the firm isn't trying to have a practice that focuses on and invests in athletes, do you want to continue to be there? And do you want to go somewhere where you have the ability to continue to learn, grow, and work with these athletes and provide the solutions that they need? You know, I'm kind of fortunate. I started off in a place, didn't have a sports practice. And so they kind of gave me some ability to start building it out early in my career. But then I realized I wasn't really getting the support. Like it was kind of on paper, like, yeah, we're going to do some sports stuff, but I really wasn't getting the support I wanted. And now I'm in a place where they didn't have a sports practice, but they understood because they had some athlete clients. And so what I've been able to do is kind of bring that together and build it out and grow it over the years. And so the support is entirely different, right? And that support matters because it's not like, and I had this conversation with some attorney colleagues, like, it's not like I can go to the local CBA meeting and, you know, like bar association meeting and like meet with some potential clients who need some tax work, right? Or a generic corporate client, right? It's not like athletes as clients are just right down the street where you get as clients. Like it's work to build a practice of professional athletes, professional entertainers, and you kind of have like one shot to get it right. And if you do that, then you can set yourself up for success. So having the support of the firm is a big deal. But if you want to talk more offline, shoot me an email, shoot me a DM. I'll give you my information and we can connect.
Thank you very much.
So Darren or Jordan, do you have anything to add to that question, or would we like to move on? Gotcha. So our next question is from Adam Weissman, and it says, I'm curious how the 2020 update to the trademark law has affected people's practices so far.
I'm not gonna lie, for me, it's made me a little more aggressive, but in a good way. Because of a certain area, I don't want to make it too convoluted, but you can almost like pre-petition an application. So one issue that I've come across is something that the trademark office is trying to crack down on is a lot of like almost fraudulent foreign applications that kind of block up the trademark office. So you could get a likelihood of confusion, and this happened to me. My client got a likelihood of confusion rejection based on an application that has zero presence in the United States. Once I started digging in on the company, they're some type of like limited company out of India that have they sell zero products here. You can kind of tell like what they submitted as their proof of use almost looked more like a mock-up before the USPTO outlawed mock-ups as allowed specimens. So like all of these different things that don't show proof of use, and use is a requirement under trademark law. Use and distinctiveness, those are the two basic requirements when it comes to registering a trademark. So for me, now that this law is in place, it allows you to basically petition the PTO outside of just a cancellation proceeding for the like legitimacy almost of a registration. So for registrations like that, I'm starting to draft up my petitions and send them out, because if there's no actual use in the US system, then that registration needs to be abandoned or vacated, which is the same thing that could happen through a cancellation proceeding, but those are significantly lengthier, they're more time consuming, they're more expensive. So if this is an easier avenue, I'm gonna try to figure that out before I go the cancellation route. So for me, that's kind of how I've been using it, or my interpretation of what the new a new portion of the Modernization Act says.
Thanks for that response. Our next question is from our Sports Law Society president here at Tulane, actually, Ms. Hannah Holmes. She says, one consistent aspect mentioned about being a good IP lawyer is staying up to date with the industry. Ms. Franklin specifically mentioned doing this through constantly reading and writing. Do you all have any advice for law students who want to start writing / where can law students go to get help or get published?
I'm happy to address this. I was asked this question actually earlier today by a student, and I think, first of all, we're all brands. You, me, we're all our own brands, and we're really all our own marketing agents for our brands. And I thought I was fortunate to be going through school when Facebook first became available when I was a sophomore. Twitter started really sprouting up when I was in law school, and LinkedIn and so on and so forth. Platforms that allowed us to self-publish, where in the past, there was not that opportunity. The immense power in each of our hands is something that we shouldn't take lightly. It's something that we should always try to game plan and exploit properly without oversaturation, without losing our voices, figuring out what your voice is and sticking to it. And also always understanding that one wrong move can tarnish your reputation. But to answer your question specifically, you don't necessarily have to find a specific publication to adopt you and to publish your articles. I mean, it's great to have something like a Forbes or an Inc., which certainly helped give me credibility as I was trying to rise up the ranks. But today's day and age, I mean, you can use the mediums like Twitter, LinkedIn, and so on and so forth. Actually, the platform called Medium itself gives you an opportunity to publish and self-publish and then promote it, send it to friends, send it to colleagues, send it to future potential clients even. You never know who will be a potential future client. So the technology puts all of us in this situation that 20 years ago, none of us would have had. And it allows all of us to build our brands and continue to build our brands and even modify strategy when we deem it appropriate. I mean, I've never spent $1 in advertising in over 10 years of practicing. But 20 years ago, I probably would have had to. I don't know how else I would have necessarily gotten word out in the same way. So if you write good content, you'll find an audience. One thing that I firmly believe in, and I say this to a lot of people who tell me that they want to be sports agents, but they're concerned because it's so oversaturated. There are so many agents and so few clients to actually recruit because let's say the top 10 agents represent over 20, 30% of the NFL, for instance. And I'm just throwing numbers out there. I don't know if that's accurate. What I always say is be the best at whatever you want to do. I don't care how crowded that space is, you'll find business. Don't worry about the money. Just worry about being the best at whatever it is. It could be intellectual property, it could be sports, it could be a combination of the two, it could be something else. And again, I think that you have this unique opportunity today to expose your talents, expose your knowledge, expose your experience, just due to the mere fact that we all live on our phones, for better or for worse. We're all super connected at all times, and you can just disseminate your self-published opinions online to snap your fingers.
I actually wanted to add something to that. And I'm not as, involved in social media as I was at one point, because of time. I don't really have the time to. But just touching on what Darren said, I use social media a lot to my advantage. I will say, as law students, you have a deeper understanding of concepts that could be more convoluted to a layperson. So it literally could be as simple as, I'm on Twitter more heavily than I am on like Instagram or something like that. So something as simple as retweeting an article and like in the limited characters you have, explaining what it means. So I know Darren talked about the circuit split with the copyright issue that the Supreme Court ended up deciding. So the circuit that I'm a part of and that you all are a part of too, which is the Fifth Federal Circuit, we all had an understanding that you did not need the registration to apply for or to be able to sue someone for copyright infringement. And what I mean by you all is like the state of Louisiana and Texas. It's all part of the Fifth Federal Circuit. So when that decision came out, I did a small blurb on like, this is what this means as a creative. This is how it impacts you. What 180 characters is all I needed it, or all I like kind of summarized it for. And I went viral. I think by the time I shut it off, I think it had like over 100,000 retweets and likes. So something literally that quick. As a law student, you know what those things mean. I did the same thing with the Megan Thee Stallion situation. I just did a quick blurb on, hey, it does not look good for Megan. Here's why. Here's what I would have done differently. And I got one of my biggest clients from that. I'm sure if you all are familiar with who Tika Sumter is. She's an actress, but she somehow, I was trying to work with Megan. I'm not gonna lie, I'm like a huge Megan Thee Stallion fan. And somehow Tika sees it and she was like, I would love to work with you. And I'm like, okay, well, a win is a win. So literally it was something as simple as just explaining something in basic English. And that kind of touches on what both Luke and Darren said earlier about a test of your knowledge is being able to really explain something simply to where a layperson can understand it and be like, oh, dang, that's what that meant. So that is also too a test of your knowledge. So I would do stuff like that all the time, just like basic, simple language, and stuff would go viral. And then a lot of traction would happen. And then, you don't spend $1, maybe 15 minutes of your time, maybe a little longer if you have to read the article, but it's like, it's a skill that you should take full advantage of.
So we've got about 4 minutes left, and this next question is actually a pretty good way to end, and it's from Philip Muldari here at Tulane, and he asks, what do you wish you had known about your field before you started, and what do you find most challenging about your job, and what are you currently facing that has been your biggest challenge?
That's a lot. I think I forgot the first part of the question, but just generally, I guess the thing that I wish I would have known. I mean, I think more than anything is, it's all about like time management, to be honest with you, right? And it's about being able to say no. When you are good at what you do, you will have a lot of people who will want to have you do different things. And as lawyers, in case you didn't know, you're going to be asked to like be on boards and to like do all these different things that you're going to have to figure out. As Darren said, we all have brands. You have to figure out what is your brand, and like, what is the lens through which you're evaluating the things that you're going to say yes to, that you're going to engage in? I don't know that I necessarily had as much of an appreciation for that early in my career. You know, you want to say yes to everything. So you're like, oh my God, somebody asked me to do something, like I'm so in. And you start saying yes. And then you're like, okay, whoa, actually, I need to start learning how to actually say no and be very strategic about the things that I'm saying yes to, right? Have a plan for kind of what it is. So for just as an example, for me now, it's about my life professionally and personally is about education and protection, right? So if it's with athletes that I'm working with, like how can I educate them and how can I protect them? And if I'm being asked to do something that doesn't kind of fit that lens of educating and protecting, then it's not just for me. It may be something maybe that I still think is a great idea. That's great. I support you, give you love, but it's just not something that I can commit to. So I think figuring that out for yourself of what your lens is, what your kind of brand is, and being able to articulate that, I think will help you as you progress through and begin your career.
Yeah, I think what I wasn't necessarily prepared for and what I wasn't necessarily taught in law school is just how much time we spend not necessarily quote unquote lawyering and actually serving in a type of therapist role. And we don't necessarily have that background in education, but we do our best because we want to make sure that we do what we can to help our clients and support them. And I guess the biggest challenge, I think for me at least, in terms of not only being a lawyer but also running a law firm, is definitely the time management component, because I have to wear multiple hats. I am a lawyer. I just finished a 4-day arbitration hearing yesterday with the Major League Baseball Players Association, which completely consumed my life. But at the same time, I'm running a law firm, and that was not my only client that needed my attention during those 4 days. And so I'm not just a lawyer, I'm an administrator, and I have to make sure that nothing's falling through the cracks, whether it be deadlines and other matters, whether it be existing clients with urgent issues, whether it be potential new clients. I don't want the fact that I'm consumed and occupied to preclude us growing. And it's not just myself, but we are a small firm. So I think that's probably the biggest challenge.
I don't really have much to add. I agree with both. I felt like Luke was in my office because I have a really hard time saying no. But I think that's a lot of my newness still that I'm trying to get off, and balancing my time as well. And then two, I guess one of the hardest things is having people, especially my friends, who you're trying to start businesses and all these things, understand that, you know, my schedule now is not as free as it was a year ago. Especially in a firm setting, as a first year associate, you'll have responsibilities. But when you hit that second year and they see, okay, she can generate business, she can do this, she can do that, they're going to like quadruple your workload fast. So because of that, your availability and stuff is different. So just kind of finding that understanding, time management, like Darren said, again, kind of the no, like Luke said, all things that I'm still working on myself too, as a young practitioner. And yeah, I will say those are probably the biggest things for me too. So, I felt like they were lecturing me as well.
Thank you, everyone. And just to be respectful of our panelists' time, we will end here. And I'd like for everybody to give the panelists a virtual round of applause. I know there might be some unanswered questions. So what is the best way to reach each of you if you are willing to answer any follow-up questions from our attendees?
Skylar, I think you have my email. Email's usually the best way for me. And I'm always open to setting up like a virtual coffee or something like that as well.
Yeah, feel free to share my email address as well. That's fine.
Same on my side, and I'll do a little plug. You can find me on social media at Darren Heitner. Always Brandon.
Thanks, everyone. And last but not least, be sure to follow Tulane Sports Law on Instagram for our next events at Tulane Sports Law. And thank you, everybody, for joining today. It was a pleasure. Thanks to our panelists as well.